the issue, I don't think I can tell you I have no personal experience with this, but what I see is what's in the newspapers and on the internet about people being turned away from, or essentially turned away, functionally turned away from emergency care, and who have some distressing outcomes, and it's making us look very bad. And yet, actually, when you look at the news, it really says it doesn't blame the emergency physicians. It blames the place that we've been put in by the battle between states' rights and the federal government. So, why don't you give us a little background about what's going on here?
Well, I'll start with, I mean, what you read in the papers are certainly the most tragic, interesting stories. I live in Atlanta, and in Georgia, the story of Amber Thurman has been widely publicized, of a young woman who went to North Carolina for a medicated abortion, came back to Georgia, had complications, and there are allegations that, you know, physicians, hospital was afraid to treat her for fear of criminal prosecution. I haven't seen cases, that interesting or, incendiary in my work. But I will say that generally in the EM industry, there are claims out there. There are complaints, there's medical board actions, there's EMTALA complaints, and yes, there are malpractice claims out there kind of related to this overall kind of allegation of, medical providers are not providing appropriate care for fear of criminal prosecution under the 20 or some odd states with restrictive abortion laws. So I can confirm for you, this is a challenging legal area for EM physicians. It might not be as challenging and risky in the way that they think it is, which I think we can kind of uncover layer by layer as we discuss here.
I saw some recurring news about Idaho and what's going on in Idaho when they were asked to kind of see which whether it was state or EMTALA would prevail, and all of the stories I saw, it's like I scratched my head and said, well, obviously federal law prevails. And why would these make newspaper stories out of them? They may have some state laws, but the federal law is the law of the land. And apparently there's some backsliding on that with regards to some definitional issues related to saving the life of a mother, saving saving organ capacity of a mother, those kinds of things where they kind of want to split some hairs to see whether an abortion is the appropriate treatment or not. And so we were waiting for the Supreme Court to say, what's the answer, guys? And we haven't gotten one yet. They
punted. They punted again.
Yeah. And so in the meantime, that leaves patients and physicians and the state laws in a bit of a quagmire.
You're right, Rick. And I got a question for Dusty. You brought up an important point that, hey, if the federal law is out there, you need to follow it. So let's think about preemption. If the federal government decides to rule or legislate in a certain area, it preempts any state law. The state can legislate in that area, but they have to exceed what the federal government has. They can't make something lesser. But what's fascinating about this, in my opinion, this is where I'd really like to get your expert opinion, Dusty, is EMTALA certainly is the federal statute, but it is not specifically governing reproductive rights. So it's not necessarily governing the exact aspect that these state statutes are now, which is why, yes, you've got to comply with EMTALA, but it doesn't give the full coverage that normal preemption would. And that's creating some of the ambiguity and some of the confusion. Would you agree, or do you have a different perspective on that?
Oh, absolutely. I think it is really stretching, EM and OB providers in those relevant states really, really in two very difficult directions. The Idaho case is particularly interesting. Idaho has a very restrictive law. And shortly after the Dobbs decision, I believe it was the director of CMS sent a letter basically to the entire industry stating, don't forget, EMTALA, is still the law of the land, preempts state law, and you're required to provide medical screening exam, emergency treatment and stabilization, which may include, reproductive care in certain conditions. Idaho sued, over that guidance from the federal government, and it has, wound its way through the courts, even up to the point where Rick talked about, the Supreme Court dismissed the case. They're not going to provide review, sending it back to the Court of Appeals, and we're back in limbo in that dispute between EMTALA and Idaho law. And I think we can even expand that to EMTALA and all of these, restrictive laws across the country. I'm going to throw a wrench into the gears, though, because if you weren't paying attention, there was an election last Tuesday, and
What?
yeah, there was some commercials here in Georgia. In fact, it was every commercial. But that guidance on EMTALA still controlling in emergency situations in these states where you have these restrictive abortion bans was from the Biden administration. The Trump administration could turn around and put out a completely different guidance, and they could really kind of make moot this argument between EMTALA and the state laws. So I think it remains to be seen where that's going to go. Right now, it's in limbo in the federal Circuit Court of Appeals, but the administration could change that. The new administration.
I just have a couple of things to say on this, and that is that one of the things that has always kind of tweaked me is when we start to politicize emergency medicine and medical treatment. And one of the things that I would caution is to say that EMTALA, in my opinion, is still going to trump state law. But, when we look at some of these, I just want to give some background on some of these sensational cases. As an example, the one in Texas, that was basically a case of an ascending infection. And I want to point out that ascending infections in pregnant women and postpartum women have always been a big issue. And it precedes the abortion laws, and it has certainly been a big area of maternal fatality. So the CDC and prevention reports showed that infection has been a leading cause of pregnancy-related deaths for many, many years. For example, in between 2017 and 2019, infection-related deaths accounted for about 16% of all pregnancy-related deaths. And so I think sometimes we need to be careful in scrutinizing these cases and be sure, was that patient not treated because they were pregnant, or was this a malpractice case? And we don't know sometimes because the physicians involved aren't able to talk about these cases. These are malpractice cases, and they've been instructed not to talk about it. And the media can take these cases and run and say, hey, she was pregnant, she wasn't treated. So I think we need to be careful with especially the doctors who are involved, because we don't know what their motivations were or were not. I would say that if a physician is not treating a patient because they're worried about criminal liability, and they don't treat the patient for that reason and allow a serious infection to cause the death of that patient, yeah, they're going to be in trouble. But I don't want to make the assumption that that's what's happening in all these cases. And certainly these, the number of deaths among women is very high because of these infections, and it may or may not have anything to do with abortion laws, whether they're lenient or even California has a huge problem with maternal death due to these types of infections.
You're right, Jen. And I think, I think people are focused on changing legislative initiatives and regulatory language, but I think there's also an opportunity, and I think, Dusty, you hinted toward this in your introductory comments, that some education is owed to the clinician. So in other words, we can try and debate today what we think is right from a legislative and a regulatory standpoint, but I think people have put a hard stop on doing certain things that they actually can still do because they're fearful of the outcomes when they're given an out for this in the legislation. So just to give you an example, you pull up an article that was published August 12th of 2024 in Center for Reproductive Rights. There were two cases in Texas where two individuals had ectopic pregnancies, and allegedly they were sent home because they said they couldn't get treatment for that. But when you look at what's in this article, as they summarize that the Texas law allows that exclusion. You had an ectopic pregnancy, you go ahead and have that treated the way you normally would, whether it's chemical with methotrexate or whether it's surgical. This is what you do. But for some reason, the disconnect occurred with the clinicians to say, hey, we can't do it. I'm going to send an ectopic pregnancy home without treatment. That's just not in the patient's best interest and didn't really comport with the letter of the law, which gave an exclusion for this. So again, not speaking to the right or the wrong or the moral or ethical implications about the legislation or the regulatory language, but our people have to know how to apply the legislation and the regulatory language so that they don't make mistakes. And I believe there are EMTALA implications in both cases.
Yeah, and I
Yeah.
would, and Kevin, I would say, look, if you are not treating an ectopic pregnancy, which is an emergency condition, if you are not treating an ascending infection, which is an emergency condition, then you're violating malpractice laws and you need to treat the patient. And I guarantee you, you will not be charged with a criminal offense if you are treating an ectopic pregnancy. It's not going to happen. So get it out of your mind and treat the patient.
Right. Good point.
In the case I mentioned, Amber Thurman in Georgia, there was a recent story. It was leaked to the press that the state's maternal mortality committee looked at that case and determined that that was a preventable death. In other words, that this was a patient that could have been saved under the relevant standard of care and as allowed under state law. I will extend some some sympathy, empathy to the physicians who are scared. I get that because I mean in Georgia it's a felony. In Texas it's a class 1 felony. I mean you're looking at 99 years. So the fear is based in a real place. But it's a difficult situation you're in. You're pulled by EMTALA, you're pulled by state law, you're pulled by your typical, malpractice risk. But one theme I think we'll come back to over and over again during this segment is, the risk of malpractice is real. I've seen it. I've seen the risk of EMTALA complaints. That's real. Medical board actions. They could go to the press. Those are all real risks that are happening right now. I have not had one. I've had 0 acute care physicians even threatened with criminal prosecution, and we operate in a lot of these states. So I'm not saying it would never happen. I'm saying you are in a difficult balancing act. So I'm giving you the facts and the data. The malpractice cases are happening. The criminal prosecutions are not happening. So keep that in mind as you're weighing these difficult risks. And when in doubt, just like that probably old advice, Rick, you've given many, many times, is just when in doubt, do what's right for the patient, and you're probably going to be fine.
You're exactly right. It's patient. Then I think it's EMTALA. Then I think it's state statute. And I will tell you, you've got to do what's ethically and morally right for your patients. And I tell you, groups can help. And I'm not putting, you on the spot, but just in a general global statement, Dusty, policy can help protect people. So if we have policies in place, whether it's at the hospital level, whether it's at the group level, this is what we expect of our clinicians. Do the best thing for the patient based on the circumstances, document it well, and we are supportive of that. Not taking a political position on those, on the legislative initiatives of the day or of the time, but really those policies can support our clinicians to do what they need to do and have the protection of the organization.
I actually see a silver lining in all of this. 80%. So the CDC estimates that over 80% of pregnancy-related deaths in the United States are preventable. And there are a lot of deaths in pregnancy in the United States. Our maternal care is not up to par when we compare it to our European colleagues and elsewhere. We are not at the top of the pile. And so what I would say is this is a great, great opportunity to review our protocols in sepsis in pregnancy and our practices and how we treat people in pregnancy and really kind of focus down on that, because boy, there's nothing worse than a death in pregnancy that is preventable, not only the mom but the baby as well. And so I view this as a good opportunity to get better.
Well, Jen, to your point about kind of the deficiencies that are already there, the bad cases that already happened, irrespective of if you're in this state or that state. And Kevin, your point about documentation. One thing I have seen is that you have bad outcomes, or even outcomes that aren't technically bad outcomes, but a patient might perceive them to be a bad outcome because they had a painful course. Well, now you have this new perception that's really being fed by these stories that we're talking about. So in the past, you might have had a patient say, wow, that was a rough, maybe miscarriage. I wonder if the ER could have done something better. Now, kind of infected in that is, I think they were afraid of those laws, and that's why they didn't help me, which is a reasonable perception if you don't address that elephant in the room.
Right.
So I think you can address, you can and should, I think, address that with your patients and in your documentation. If you have one of those not gray area, but a patient maybe who's worried about that, why not address it with them? Address it in your documentation. Hey, I am not the law that you're worried about is not applicable here, and we're going to treat you the best we can.
I agree. And Dusty, I will say, and you may not be aware of this, we've had similar conversations on different topics with Risk Management Monthly. I think you need to invoke the administrator on call or the legal expert at your institution, because instead of making a medical decision, you're making a legal decision. And most of the clinicians are not qualified to do so. And no one is when you're in the middle of taking care of a patient. You shouldn't be trying to make a legal determination at that time. So if it's like, hey, listen, I think I'm going to be at risk and I'm going to run afoul of this statute, I'm going to get a hold of whoever I need to, and the hospital has to provide a mechanism for that. Hey, general counsel, hey, risk manager, hey, whoever it is, I have an ectopic pregnancy. This is what OBGYN is recommending. We want to do that. Are you okay with that? And it goes in the medical record. You don't have to be alone on this. Do not make a medical determination, a legal determination when you are trying to make the right medical determination with your patient and for your patient.
Yeah. And, I think one of the biggest risks right now is that there are people who are looking to make this an issue. Like they're looking for cases and they're looking for a reason. And so again, I think that, doing the right thing by the patient and documenting is going to be really key in not only protecting you, but more importantly, and your number one priority is protecting the patient.
Rick and I discussed that in similar, you've encountered similar instances in the past, granted not with as grave of potential penalties, but you've encountered as an EM physician potentially legally risky areas. How about the police officer who brings somebody in and says, I want you to search them? And I think back to the point of, hey, call for backup in those tricky legal situations. Of course you would call the hospital, administrator, risk manager, your medical director to get through that tricky legal situation of, say, a sheriff's deputy saying, I don't care what the patient says, I want you to sedate them. And you have navigated that in the past, and usually you've done what's right for the patient and everything's been okay. So I think this is a similar situation. Do what's right for the patient and call for backup, like you said.
Right.
document carefully, and you should be okay.
I agree.
I think one of the issues here is there are a lot of people splitting hairs about whether, in fact, this law allows you to act in this situation, and that the clinicians are not up on that. They're not expected to be up on terms of the splitting of the hairs, and so I think in some cases they just are backing off, saying, "Yeah, I'm not sure what the specifics are, but I got to stay away from this because I could lose my license, I could go to jail, I could this and that." And I think that must be occurring because of the cases that you read. Now, Kevin and Jen, we talked about an article last month that just talked about 100 women who had issues related to being in an emergency department and supposedly not getting the care that they should have gotten, and it made us look bad. And I don't know if that all those numbers are true or not, but it got the job done of making us look bad. So I think that emergency physicians need to basically fall back on some routine procedure when they're in gray zones that they're not comfortable about, and do the things that you've mentioned. I do acknowledge that it's not likely that the hospital administrator on call is going to know any more about it than you do, but at least you went through the process.
Right.
And the note that Kevin, you talked about, that would seem to be helpful.
Mhm.
And you have to remember, yes, there may be some risk, but what jury is going to send a doctor to jail because he tried to do or she tried to do the right thing in this case, and that, well, maybe he wasn't familiar with the exact letter of the law, and he stepped over the line.
You're right, Rick. And I support your comment too, that, hey, maybe the administrator on call may not be even as well positioned to make the legal or operational determination. But that's a knowledge-based question. I want accountability in the process. So the hospital needs to make somebody else other than the clinician responsible for a legal decision. And I think you want to prepare. I will tell you this. There are many hospital systems and many hospitals require EMTALA training before an administrator can be on call. Well, maybe we need training in this area for them to be on call so that they can be the most educated and informed about this when they're making the determination. But back to your other point, if you follow the process that is outlined for you to get guidance on this topic, it is no longer your responsibility to answer that legal question. It is someone else's. And that's the important distinction I want to draw here, that if you decide to say, well, like Dusty said, well, they've handed me, a court mandated, direction to lavage a patient or sedate a patient or do whatever, and you decide, well, I'm going to do it or I'm not going to do it. Why did you choose to make that decision? I'm going to call the administrator on call and I'm going to go see another patient. When it's all sorted out, I will do my job when I get direction. But yeah, I think so many of us, we're in control of our department. We just want to say, all right, I'm going to make the decision. Well, then when you choose to make the decision, you also accept responsibility for that decision. And I want to offload that responsibility from emergency clinicians so that they can get a higher order opinion through a process that's predetermined. And that will insulate you from liability to a certain extent.
The other big issue here is, what are we actually talking about? What treatments do we ourselves as emergency physicians do in the emergency department that would violate the laws?
Sure.
I personally think I don't prescribe, Plan B. I don't do that. That's something that an OBGYN would do. So I can't think of a single treatment that we would do in the emergency department or evaluation that we would do in the emergency department that would violate any type of state law. So, like, if you have an ectopic pregnancy or you have any type of emergency condition in pregnancy, that's not something that we treat. We evaluate that, we work it up, and then that goes to an OBGYN. And so you should have zero heartache or zero concern in your treatment of that patient. Ultimately, any termination for health of the mother is not going to be your determination.
Right. Well, I agree with you from a procedural standpoint, Jenn, but when it comes down to the counseling provisions, we always talk to our patients. We counsel them. We give them advice. Some of these state laws prohibit you to counsel in certain ways. And that makes people nervous. Matter of fact, I won't spend a lot of time here, but I found this article in JAMA Network. It was from last January. They basically did a survey of 54 OBGYNs, and the things that they were worried about are legitimate concerns. Now, whether they actually are completely founded in every state's statutes, I can't say, but I'll just read a couple excerpts for everyone. Many participants described needing to delay medically necessary care until patients were at risk of death or permanent impairment, or the fetal heart stopped spontaneously. Clinically inappropriate delays and their consequences also occurred during middle of the night emergencies when calls to legal teams for clearance to proceed went unanswered. There are concerns about, if I can find it here, about the counseling piece. Let me see if I can. I don't see it specifically here, but that is noted in this article. So if you want to look at it, this is JAMA Network, January 17, 2024. And it's opinion-based, but it really speaks to what the legitimate concerns are of clinicians out there. Granted, they're not emergency clinicians, but OBGYNs have some legitimate concerns. But again, I go back to clarifying and making sure that they take care of the medical care and someone else makes a legal decision.
Well, I think Kevin, that those concerns are relevant for EM because of the fear that it induces in our clinicians. And so kind of, again, I'm not worried so much that we're going to have some criminal prosecution on our hands for, whatever you do in the ER to maybe help a miscarriage along, but rather that we're going to have clinicians who are afraid to do anything.
Exactly.
And just convince themselves
Exactly.
that it's okay for the patient to go home when really they maybe know better. And it's not that they get prosecuted criminally, it's that they get sued for malpractice. That actually concerns me more, and I think is a more real potential negative consequence of these laws that I've seen.
And I think that, like, if you look at some of the cases, the biggest risk is if someone is miscarrying, for example, and they have an open Oz. That is where you're going to have the introduction of bacteria and the ascending infections. And so, it is those times that you do need to be concerned about. But again, I think treating the patient as you normally would, referring that patient as you normally would, I would urge all of our listeners to not be afraid ever to do those things, that you will be protected if you do those things. With the caveat of what Kevin said, and I think it's a really good point, and that is on the counseling piece of it. You have to know what the law is, but we have to know what the law is and everything. And so I think the biggest thing here is that there's confusion, that it's different between states, but it always has been. And just, making sure that either at the state level, whether it's through ACEP guidance or through I don't know, your medical director and your ED to get guidance, to ask for that specific guidance, so that there's policy also that you can rely upon and lean on if any cases come up.
Yeah. Good point. And I did find that quote. I just got to state it really quickly. So, although most reported that they will counsel, but not document discussions, such conversations were felt to be risky. So they were counseling and then they were not documenting appropriately. That is absolutely the wrong pathway. You want your documentation to reflect your careful medical decision making, no matter how complicated, and especially when it's complicated like this. But what these 54 OBGYNs resoundingly said is, oh, we're counseling. We're just not going to be held accountable for it, so we're not going to document it. That's a critical piece of documentation.
Well,
The other problem with that is that if you don't document it, eh, I mean, you have nothing to rely upon if it does go to trial. You can say that, but then it's your word against the patient's. If you have a contemporaneous notation of what you actually said, I mean, if you're going against law, then, maybe that's the problem.
right.
And you probably don't want to document that, but then you shouldn't be doing it in the first place.
Well,
Just,
I
just
again
okay.
validate the fear out there, and in reading through the cases, some of the the really tragic stories, I just get the sense that everyone was afraid, and it just kind of created this groupthink fear mentality, and just nobody did anything, and nobody was willing to stand up and say, you know what, this isn't right. We need to do this for the patient. It takes courage to do that. That is the job of emergency physician. That's what they are good at. To stand up and say, hey, I understand y'all don't know what we're supposed to do here, but here's what I think is right for the patient. Who do we need to call to make sure that she gets the care she needs? That's what emergency physicians are great at, and that's what they have to do in these situations to prevent these bad outcomes.
The one caveat I would say, though, is that without a doubt, I'm sure that there are cases like this that are happening. I would caution people to make judgments based on sensationalist articles that come out because we don't know. I mean, is this just malpractice? Because there's a lot of it. Again, over 80% of deaths are preventable. What does that mean? It means that we should have prevented them and we didn't, whether it's failure to recognize sepsis and an ascending infection, as one of these sensationalist cases shows. But we don't know. We don't know that those doctors can't talk about it. They can't say, look, I missed it. Of course, they wouldn't say that, but certainly that happens all the time. And again, I would caution to say that, well, it's because of this new law. Again, I'm sure that it will happen because it's confusing, but just, be kind to our colleagues and don't rush to judgment.
I agree. And I get worried. You just brought this thought forward, Jen. If you use that as a defense strategy, there are going to be plenty of people to say you misinterpreted the law. You always and always take care of your patient, doctor. Isn't that your oath? I mean, I can see that going so badly for a clinician defendant, despite the fact that it may be true. So I would caution anyone, be really careful with saying I knew to be wrong because I was trying to avoid prosecution in a statute that I either may have interpreted correctly or may not have.
Well, don't you think that the safest thing to do is uh, acknowledge that there's this law, that there are some nuances in this law in this state, and therefore I'm just going to step back and not treat. And I think that is a real danger because that they may be not treating patients that the law really doesn't address, and yet they're going to be sending patients home. It's one of those things where I think sometimes when you have a case, you can convince yourself that this person can go home when they really ought not have.
No.
Dusty, do you have some, like, for your groups, do you have some general recommendations that you teach your doctors with regards to this issue?
Yes. This podcast is among other town halls and educational sessions we've done. And one other thing, that we've provided, I think other groups have provided, but I encourage EM physicians and clinicians to check: is this covered in your malpractice insurance policy? Most malpractice insurance policy have some limited coverage for criminal defense. Say if you get prosecuted for battery related to your treatment of a patient, usually there's provisions in insurance that covers you for some limited criminal defense. And now, of course, if you did it and you were maliciously harming someone, it might end up not being covered. But I believe most groups have endorsed their policies to provide for criminal defense, in the very unlikely event that someone tries to prosecute an EM physician for doing the right thing for a patient. So I do encourage EM physicians to call their insurance company and check, is this covered
That's-
if I get?
And Dusty, doesn't it usually states in the provision something to the effect of in the normal course of duty and responsibilities in your
Correct.
role?
It's
Yeah,
it's under your usual insuring clause of treating a patient.
right.
I've seen it come up of alleged battery, alleged wrongful imprisonment, alleged sexual assault, related to regular course of treatment of a patient. And these provisions are helpful to make sure the
Sure.
clinician gets the defense he or she needs.
Agreed. One other thing that I'd like to just throw out for your consideration also, going a little different direction here, really to make sure that not that billing isn't maximized, but optimized. Critical care has been a focus for a long time. And really noting that even what seems routine to the emergency physician, because emergency physicians and clinicians are great at what they do, doesn't mean that this didn't qualify for critical care. The reason I put it in this context is for people to consider you have nuanced documentation practices in certain areas. That happens to be a charge capture nuance. But a risk management nuance here is, hey, this is a pregnancy related concern. Anything you do, you should say, we gave methotrexate. I called the OBGYN. I counseled the patient. This is potentially and likely a life-threatening illness. You've got to say that, because if there's an exemption in the state statute for this being life-threatening to the mother, you darn well better claim it in your medical record. And I think you need to say that if you're like, she's fine right now. We're not talking about right now. We're talking globally. You need to have the justification to say, I'm going to intervene the way I normally would for an ectopic pregnancy or whatever entity it is, because I'm concerned about a true threat to this person's life. It doesn't have to be today, but the genesis of it begins today, and I can stop it from happening. And I think that has to be clear in your documentation.
For risk purposes and all sorts of good purposes. And I think clinicians can have kind of the mistaken belief that in those gray situations, those kind of scary legal situations like we've been talking about, if I don't document too much, maybe I'll slide under the radar, which is inaccurate. And in fact, I've seen the opposite of, lack of documentation, making it harder to dispose of a case that should easily be disposed of if we just had good documentation, exactly like you were talking about, Kevin, describing the emergent situation, describing the duress the patient was under, communicate to the patient, that I understand this law is out there. You might be afraid I'm not going to treat you because of it. That's not the case. I'm going to treat you to the best of my ability, and putting that all in the record.
And Dusty, I tell you, the only reason I was smiling as you said slide under the radar is because poor documentation slides you right into the radar.
Yeah.
Dusty, do you recommend that what Kevin has suggested, that documentation of attempts to reach the hospital administrators would be helpful as a relatively routine matter in these cases?
Yes, I always counsel that in tricky legal situations, from AMA to body cavity searches to this one as well. Putting that in the record certainly won't hurt, might help.
But let's protect the hospital interest too. I wouldn't just have somebody go to a shift the day they hear this and then call the administrator on call. There has to be a process built and a policy to support how that is used. And I think most hospitals would suggest that, okay, that's a pretty good thing. We do it for EMTALA, then this is EMTALA related, but also very important as this landscape has evolved. We need to put this in the scope of practice of the on-call administrator. So just calling somebody who's not prepared to answer the question, maybe shifting the blame or sharing it, but that's not so helpful. But letting the hospital know, let's set up a program for this because this is the best way to do it, I think protects everyone.
Yeah. And hospitals, I think, have gotten pretty good at setting up those protocols for some of those old school legal situations we talked about, like those, police bringing somebody in. I've seen those policies and they're quite robust. So even more so in these situations, those policies are necessary.
So should we wrap up with the idea that we fall back on the goodwill, do the right thing, and document like hell?
I did want to add one last point. I mean, this is difficult and will continue to be difficult. If you are interested in advocacy to make this easier in your particular state, I spoke with the president-elect of ACEP, Tony Cirillo. He said this is a very state-centric issue. So if you're looking for a place to get involved, talk to your state your state ACEP chapter, and they can help advocate for changes in the laws to make this easier. In Texas, there is a bill that I think might make this easier for EM and for OB. So there are advocacy groups out there in your states, the state-based ACEP chapter. If you want to get involved, go for it.